You're listening to the Alliant Specialty Podcast, dedicated to insurance and risk management solutions and trends shaping the market today.
Well, hello, everyone, and welcome to another edition of the Alliant Specialty Podcast. I'm David Finns, and with me today we have a special guest, Steve Levine, Senior Vice President in our Claims and Legal Specialty practice. Steve, welcome to the program.
Thank you, David. It's wonderful to be here. Looking forward to talking with you and all of our listeners about the recent SEC final revision to their data privacy rules. The final revision to the data privacy rules governing many financial entities, and this is what we refer to as Reg SP. These new requirements are going to apply to registered investment advisors, broker-dealers, investment companies, funding portals, and transfer agents. David, would you like to tell a little bit about what this Reg SP will do for us?
Sure. Thanks, Steve. And again, what's really interesting about this topic is that it cuts across multiple lines of insurance coverage here in terms of where we can expect our clients to be able to transfer some of the risk associated with this. So the final rule requires these entities to develop written protocols to protect clients' confidential information. And they also need to have mechanisms in place to identify unauthorized access to data and to create an incident response plan, which, along with having the right containment and remediation measures in place, right, also needs to include a procedure to notify the impacted customers of any breach. And that has to take place within 30 days of the regulated entity discovering that they've had an incident. Additionally, the final rules mandate due diligence around a firm's monitoring of its service providers, who themselves may experience a breach, and to deliver privacy notices to customers on an annual basis. Now, there is an exception if there's been no change in policies and procedures year over year. They don't have to necessarily provide that annual notice. And these new requirements will take effect on July 15th, which is 60 days from the issuance of that final rule. So this is something that the SEC has really been focused on. SEC Chair Gary Gensler had issued a statement praising these amendments. He said they were going to help protect the privacy of customers' financial data. He seems to be very focused on the fact that there's a notification requirement and says that is good for investors. But one observation I have is that the service providers themselves don't have any requirement on them to notify of impacted customers of a breach. That rests squarely with the regulated entities. So again, as I often say, you can outsource the responsibility for storing and processing data, but you cannot outsource the liability. Ultimately, as a regulated entity, it rests with you to give that notice. Now, you may have recourse against the service provider. They may help you defray some of those costs depending on the nature of the vendor agreement that you have with them. But ultimately, you're responsible for making sure that that notification takes place. But the data protection rules and the incident response planning provisions of Reg SP do not extend to the service providers. And the lack of any mandate around that really heightens the importance of third-party risk management, vendor management on the part of financial institutions and their advisors. So let's talk a little bit about where the insurance coverage could come into play. Best-in-class policy wording for cyber policy includes, within the definition of a regulatory proceeding, a proceeding brought under Regulation SP. So that's great, right? The legal fees associated with responding to that inquiry and potentially fines and penalties, if they are insurable by law, would be picked up by a cyber policy. But where that coverage ends is with respect to any type of private party litigation that might ensue as a result of a breach, or for that matter, investor loss around, any hit, if you will, to the value that shareholders experience as a result of this incident, right? And Steve, that's where I think, as you and I talked about, in running up to this call, that's where the D&O could potentially come into play.
Sure, David. I reached out to you shortly after a couple of the clients reached out to me asking, well, hey, how might this impact us? And of course, I was drawn to two specific questions and areas of potential risk. You have your regulatory risk, and then you have your consumer or customer risk. The first client that reached out to me was a public D&O company, right? They were asking about their public D&O. And in that situation, their predominant concern was, can this lead to shareholder derivative actions? Can this lead to allegations of breach of fiduciary duty? And will our policies step in and cover that? And I assured them yes, to the extent that shareholders or activist shareholders or whomever are going to raise questions about board decisions or the way that these rules were implemented, then certainly we would expect the D&O policy to cover that. If any individuals are implicated, whether it be by a regulatory investigation or from some consumer or shareholder angle, we would expect it to kick in as well. I think the broader coverage, though, David, is on our private D&O side, where there is potentially coverage for regulatory activity. The private D&O has broader parameters. On the public D&O, we're limited to securities claims, generally for the entity. So we do think the angle here is to review what type of coverage could be available for fines and penalties, make sure that we are as broad as possible on our cover for such fines and penalties. And that might, in essence, be where the carrier would be expected to come in and pay. The defense piece, where there would be significant defense to actions, would be shareholder litigation, more likely derivative than stock drops. It's possible that an incident or breach can lead to disclosures that could lead to stock activity, that could lead to shareholder class actions. But I think the more logical avenue for risk would be on the derivative side.
Right. And just to clarify also, right, when I said where the cyber coverage stops, clearly privacy litigation arising from this. So if a shareholder is saying that their own data was compromised, right, that would rest with the cyber. Where the D&O comes in is really around claims of investor loss, claims of any type of misfeasance or malfeasance or failure to exercise due diligence in protecting the value, if you will, of those investments. The other point that I just wanted to make is that the final rule makes specific reference to incident response planning. And this is something where Alliant can really help our clients. Our cyber risk consulting practice does offer a variety of services, including incident response planning, reviewing a company's internal information security policies, conducting tabletop exercises, and the best part about this is you don't even necessarily have to be an existing client of Alliant Insurance Services to avail yourself of these separate fee engagements, right? So this is something that we can really assist our financial institution clients and other financial institutions with as they seek to ensure that they are in compliance with Regulation SP and that they have a plan in place to deal with an incident when it arises. Steve, anything else you want to add here in closing?
No, Dave, just other than to extend the offer that anyone who has questions or would like to discuss this further to reach out to myself or to David. We'd be happy to sit down and have a broader conversation or drill down into more of the specifics so that people can get out ahead of this and make sure they're adequately protected and or making any adjustments to their policy at next renewal to account for potentially added risk.
Thanks, Steve. And here at Alliant, we are dedicated to helping you find the more rewarding way to manage risk. And if you'd like to find out more about our service offerings, you can visit our website at www.alliant.com. Thanks for joining us today. And until next time, take care.